My beautiful friends, I just pressed the let's go live button, which means we got to wait for the stream to fire up all across the fruited plain of the internet before we go ahead and get started. It's an amazing Monday, my beautiful friends. I hope your weekend was incredible. The tubes are working. That's tremendous news. That was quick today. It's a good Monday. How about that? Hey, take them when you can get them. So let's get started, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we are talking about Jack Smith. He's a little bit upset. He threw a hissy fit. Over the weekend, he submitted a filing objecting to Donald Trump's request for more evidence, more discovery. Remember, Donald Trump says, this was not just the DOJ and the FBI that went and raided his house in Mar-a-Lago in Florida, which of course is true. They did all of that. But he says this was a much bigger scheme, almost a conspiracy, if you want to go that way, and saying that the Secret Service was involved. NARA, the National Archives, was involved. You had the DOD involved. People outside of the FBI, just their local prosecution group, were involved. Homeland Security, everybody, CIA. They wanted access to all of that information, and they submitted a very big motion to compel the disclosure of that, saying that Trump has been requesting this, Jack Smith has been denying that, and so they're asking Judge Cannon there in Florida to step in and do something about it. And Jack Smith responded to this. He's objecting. He's saying, how dare you ask for evidence in your trial? We already gave you enough evidence, and you don't need any more. But it's a big filing. It's like 67 pages, and it was a little bit weird. He was kind of defending himself and getting a little bit ornery in the filing. And even Politico agrees with this. So they said this is a big, long motion that kind of is not even relevant to the issue that you're debating in the motion, and a little bit weird. So we're going to go in and see what is inside there and unpack all of that. And we'll also hear from this guy who says they are officially in freakout mode. They're officially at the freakout stage when it comes to the immunity decision, which we're still waiting for. It might come out tomorrow. Maybe it'll come out on Friday. We don't know. But it has been taking a while, and this is causing a delay in the Trump trial. And so they're upset about that. They want trial back on track, and we'll see if they get it. And there were some other rumors that Chutkan is saying that she's even considering trial like in August, okay? And we were, cognizant of that here, saying there's a high propensity that they squeeze this in before the election. I imagine Judge Chutkan impaneling a jury in October, okay? That's how whacked these people are. They'll do anything to stop this man. So just brace yourself for that. We might actually have a trial and a conviction before the election. Still is a possibility. Now, we also have in our second segment, two segments today, because we're going to spend a little bit more time on this filing. It was a big fat one from Whiny Smith. But also, Fani got called out big time. And we were listening to last week. Fani, man, she was on a tear. She was really letting out a lot of hot air out of her office. And we read through the full filing, and we saw that she was responding to Mike Roman and Donald Trump's motion to dismiss, saying that this is just salacious. Yeah, so what if she had an affair with Nathan's hot dog or, her special prosecutor? But it has nothing to do with anything, and the case is not tainted. There is no taint at all. Show taint a bit of taint. And so we're going to go through this one because what happened is Mike Roman's lawyer, Ashley Merchant, who we are big fans of here, she responded in a reply to Fani, and she said, oh, you don't want to have a hearing, Fani. Is that true? Because remember, they said in that prior filing that they weren't cohabitating, that they were not, moving funds around, that they weren't even in a relationship. And it turns out maybe the defense, Ashley Merchant and the defense have more information about this, and maybe they were cohabitating. In other words, maybe Fani and her office are just a bunch of liars. And I know you're like, Rob, another more Fani here. It's like we've been talking about Fani a lot. It's very important business, I think, because this is not just about Fani and Nathan Wade getting their indictments on with each other in a bedroom. It's about them lying to all of their jurors, all of their constituents, and to all of America. And if they're going to lie about what they did with their money, and if they're going to lie with what Fani did with Nathan's hot dog, well, what else are they lying about? What else is lie? What else is dishonest out of their office? Okay, because this is a criminal case, and we already think the whole thing is dishonest from the very get. So if they're lying about that stuff, what does this mean in terms of spillover for the rest of the case and her office? And then this guy was over on MSNBC. He says, no one cares about the affair because everybody knew about the affair anyway. So what if they were indicting each other in the DA's office? They're allowed to do that. They're consenting adults and whatever. That's not exactly what we're concerned about. We're concerned about the pay for prosecution, the gross disparities between the two, the billing records, the collusion with the White House because there was multiple meetings between Nathan Wade and the White House. And if they're going to lie about going to Napa Valley and about cohabitating with each other, what are they lying about with their meetings with the White House? Okay, we got a lot of questions about all this. So it poisons the whole well, and we're excited to talk about it. So my friends, as you can see, we got 2 good segments today percolating out there. We're grateful that you are here and with us. I hope you had a beautiful weekend. I had a very busy weekend over here myself. Got a lot of work done, actually. And the work that we got done was over at watcherlodge.com, which we're very excited to now really get kick into high gear. And I want to invite you, my friends. We just finished our January Fitness Challenge. It was a tremendous smashing success. We gave away a bunch of scholarships, some gear. We gave away some cash prizes at the lodge. But now the Fitness Challenge is over, and we're transitioning into really what the lodge is all about, which is about sovereignty and self-development. Sovereignty and self-development. And we have a bunch of events coming up, but you got to go to Watch Your Lodge to go and attend to them. They're going to be free, but the catch here is that they're free for about 48 hours. Okay, we're going to do these live streams. We're going to do these as a group, but then they go behind the lodge paywall in the archives. And so if you want to join this stuff, you got to go register and join us when we do it live or catch the replay immediately thereafter. Otherwise, it's going into the vault. But coming up in February, actually coming up this week, I want to call your attention to this one. It is called Building Your Survival Squad, right? So what I've been thinking a lot about is my preparedness team and getting my family ready, getting my friends ready in the event that something goes down. We're down here in Arizona. A lot of stuff could happen. And so we're going to be talking about the 5 roles that I'm working on to build out my survival squad. I'm sharing that with you so you can start working on this as well. Watcherlodge.com is the place to go to sign up for that. And when you go there, this is what it's going to look like. You can just sign right up, register for it. It will be live. This is the page. So just click here and you can even add it to your calendar. We've also got some other events coming up on Saturday. This will be open for anybody who wants to join. An SDS 200 scanner, going to be unboxing that. If you're going to be taking the comms role in your survival squad, then go and register for that one, watcherlodge.com. And then we're also going to be doing a political Zen wellness event on Zoom. So if you want to join that, come and check that out as well. You can register for any of these things. Just sign up. They're all free, and they'll all be available for 48 hours after the event. Then they go into the archive. So come check it out, watcherlodge.com. And we're very excited about what we're building there. So we'd love to see you. We also have our website. If you want to get the PDFs that we're about to go through, if you want to sign up for the newsletter that goes out every morning, if you want to go to the shop and buy some gear, robertgovea.com is the website. And of course, our members only stream. This morning, we had a great stream. We talked about that disgusting border bill, and we got reaction from everywhere on that. I hope that it's dead on arrival, but you got to be careful with these people, man. They are conniving. They are dangerous connivers. And all they do is plot all the time. And so at any moment, we could have a new bill. Congratulations, America. 20 million new citizens. You're welcome. So we talked about that this morning, watching thewatchers.locals.com. If you're a member on YouTube, you also get access to the private Telegram group. We also do streams on Saturday. And we have a lot of fun. We have an awesome community. So come check us out, watchingthewatchers.locals.com. All right. And now let's get in to the meat and potatoes on the day. Jack Smith is raging out at Donald Trump in his defense. How dare they ask him for additional discovery, additional evidence in this case? Remember here previously we talked about Donald Trump saying, I want information from the Secret Service, from the CIA, from other FBI divisions, from other DOJ divisions. I want everything from the White House counsel's office and so on and so forth, because that's part of the case. This is the classified documents case in Florida. And this means that Trump wants to know who ordered essentially the raid, who ordered the hit, who said these documents are illegal. And these were classified documents. So a bunch of people need to be pinged in order to come to a conclusion. So who is involved? Trump wants access to everything. And we read through his motion to compel here previously. Jack Smith submitted a very whiny response, over 60 pages of complaining. And we're going to read through it and make fun of it. But What's so curious about this is it's not just me saying that. I know you might be here regularly. You're saying, oh, Rob, you always call Jack Smith a whiny little bee. And so what's the difference here, right? Is this unusual? Is this like ordinary Jack Smith whiny bee stuff? Or is this even more serious out, beyond your normal, routine here? Well, it turns out I'm not alone. It's not me just saying this. Politico even says, this whole thing's kind of weird. It kind of sounds like he's throwing a fit. Here is what they wrote. This is their article, and they're not fans of Trump. They're no defenders of Trump. So I'll just give you a little, background so you can see we're not alone in this. It says special counsel, talking about this filing, mounts a forceful and unusual defense of Trump and the classified documents case. The routine filing, which is not that big of a deal. We read through Trump's filing here, which wasn't a ranty screed at all, which is like, here's our arguments. Here are the facts. This is why we're entitled to this stuff. Blah, blah, blah. Thank you, Judge. Please make a ruling. But this is a public rebuttal of, quote, misimpressions that were allegedly fooled by Donald Trump. It's like, what? Methink the lady doth protest too much, sir. Special counsel, he filed a routine page at 68 pages. Mine's 67. But he said it's necessary to set the record straight. And what followed, according to Politico, was a lengthy recitation of the events that led them to suspect that Trump had classified documents. Now, the approach taken in legal briefs, they say, is somewhat unusual for the DOJ. Though the filing was submitted to Eileen Cannon, at times it sounded like an opening argument to a jury that Trump could face in the future. Now, it's unclear whether the, quote, misimpressions from Jack say that they're trying to correct or ones they fear that Cannon could believe. But the substance was aimed at countering the demands by Trump and his two co-defendants. And as we've already read through here, they want access to everything, right? Biden administration, Secret Service, CIA, everybody else. So that is the backdrop there, right? Even Politico's like, a little bit weird. What's Jack Smith up to here? Strange fella. But of course we know that because he's a deranged thug. But this is the government's response. Jack Smith objecting to Donald Trump's motion to compel, saying you don't need any additional discovery, Trump. You have everything that you've got that you need to get, and you're not entitled to one bit more. And so here it is, 67 pages out of West Palm Beach in Florida. Let's dive right into it. We'll fast forward through the table of contents. And what's interesting, it's a big, we're going to read the first part of this, and it's just kind of a big rant. Okay, here's our government prosecutors at work here. They say, all right, Judge Cannon in Florida. And I personally think that they're a little panicky. They've got this problem with this immunity case that has not come back down from the DC Circuit Court of Appeals. They are pleading to get that done quickly so they can get this trial back on track. Florida case is not looking like that's going to happen anytime soon. And now Trump has a good point, right? All of this discovery is necessary. They say, no, it's not. And they're outraged. They say, all right, Judge, Donald Trump has received substantial and timely and thorough discovery in this case. He doesn't need anymore. By early September of last year, the government had already given Trump and the co-defendants over 1.28 million pages. That's a lot of unclassified discovery and all of the CCTV footage that they got in the investigation. But remember, Trump's team can't watch it. They're like, we can't play anything, okay? They got it, they compressed it, they put it into some proprietary government, garbage, and then they spit it back out. So they got the discovery from them, and they got to get it from them because they confiscated it all. It's not like Trump can just go get copies of his own discovery. And you got to get it from the government so it's a proper chain of custody. That's evidence that they gathered through their lawful investigation, blah, blah, blah. And since then, they say we've also supplemented this. And so our work not only complies with our discovery, but it goes far beyond this. And the government recognizes it has discovery obligations, but we've already complied with all of them. But nevertheless, they whine that Trump has filed a lengthy motion to compel. How dare he want the evidence? They want abstract rulings on the scope of the prosecution team. Remember, Jack Smith says it's just like me and like these two bros. And so we've given you everything that we've got, but it's not, right? We think it's really the whole of government. Now, the motion should be denied as legally and factually flawed. Now, discovery requests must be based on specific demands tied to the case, but instead of meeting those standards, they have just submitted something that's purely speculative, and it's unsupported with false theories and political animus. And many of the requests are so difficult to decide. It's so difficult, we can't even decipher what they seek. Now, others are pure conjecture, detached from the facts that are surrounding the prosecution. And the government, anyways, has already furnished them with everything that they need. So that's kind of an intro. But then they just transition. Okay, this is like, we're just going to complain now for the remainder of this introduction. They say, the government's going to explain this soon. But before we actually explain that, which is, the legal arguments that Trump's team submitted, they say, Jack Smith, it's necessary to set the record straight. Yeah. Of all the underlying facts that led to this prosecution. So we're going to learn, what the sequence was before they raided Melania's underwear. The government will clear the air on those issues. What? Clear the air? It's like, who are you talking to? Your wife? What are you talking about? This is a court filing. This is the court of law. This is not an opportunity for that. Like, just respond to their motion. Okay, but this is what they've done. Okay, so they say, not because the court needs to resolve these factual disputes, but denying the motion before denying the motion. But we're going to clear the air because of Trump's misstatements. If those are unanswered, they leave a highly misleading impression on a number of matters. And you don't want to do that, Jack. So why don't you tell us? Okay, you can tell us. Now, after that discussion, then they say, then we're actually going to turn to the legal work. The government will turn to the underlying legal principles in their application to the defendant's requests, all of which should be denied. All right, so it's like, you've had those conversations with somebody. You're like, can you just answer the question? They're like, yeah, I'm going to answer your question. But first, I'm just going to rant and rave like a psychopath for about 20 minutes, and then I'm going to answer your question. Oh, this is one of those conversations. Yeah, you've probably, dated someone like that. Now, a word at the outset about those requests. They say Trump has scattered their requests throughout their motion. And so we have now included an appendix. They probably brought this over to Molly, the highlighter girl from DC. And she highlighted everything up and got it organized. We know how much Judge Chutkan liked that one. So they say, anyways, the defendants also have filed a classified supplement. And we think those should also be denied. So here's the background from good old Jack. He says, Donald Trump and the defendants, they rely on a false narrative about how this investigation started. We got a lot of questions about this. Now, my take on it, of course, is that the president is entitled to the opinions of his executive branches in the forms of writing, because that's what the Constitution says. And you can look that up. It's called the opinion clause. And it's in there. It says, along with other documents, the president and other responsibilities and powers, the president has the right to the opinions in writing of his officials. So I would extrapolate that to say that he has the right to any materials from the executive branch because, he's the president. And Congress, if they're going to pass some stupid bill like the Presidential Records Act, or if they're going to pass some classification laws or some classification rules, the only way that they can overcome that power is by amending the Constitution to take that away from the president. Otherwise, their statutes, the Presidential Records Act, all this garbage, okay, is literal garbage comparison to the Constitution. I don't care how wise it is or how smart it is. You don't get to pass a statute that then usurps the Constitution without amending it. End of story. That's how it works. But now they say that NARA is more powerful than the president. NARA can say, those are my papers. Give my papers back. No, sorry, Deborah. Drives me nuts. But anyways, their apparent aim, they say, is to cast a cloud of suspicion over, this is how you know it was rigged, because they tell you that these were responsible actions by government officials who were diligently doing their jobs. Okay, so Deborah Stidel Wall and all the people who turned a documents situation into criminal charges, okay, they were all colluding to make this happen. Now, the defendants' insinuations have scant factual or logical relevance to their discovery requests. So they say, you don't need all the CIA stuff. You don't need DHS stuff because it's not relevant. And we have to correct the record, saying, put simply, the government here confronted an extraordinary situation. Which is funny because they say this is not that extraordinary, right? All these Trump prosecutions are just someone is breaking the law and no one's above the law, which is insane because the president actually is. That's why he has the pardon power. Derp. But a former president, they say, this is extraordinary. They don't know how to handle this. A former president engaging in calculated, persistent obstruction of the collection of presidential records. Wow. That sounds like a monster, like, wow, it's like end of America. A persistent obstruction because they didn't go get his baseball cards back. Great. Which, as a matter of law, belong to the United States for the benefit of history and posterity. So they're going to indict a former president, current presidential candidate, leading contender for the Republican Party, because they want to get his baseball cards and put him back in the history bin, right? This is what Jack Smith is saying. So they're going to wreck the country. They're going to shatter historical precedent, 234 years of it, in order to prosecute him for history and posterity to get his baseball cards back, the overdue library books. And they say, as a matter of fact, here, and we had questions about this, like they were, flipping out before they even knew about classified documents, I think, but we're going to see what they say happened here. Then they went to go get the boxes back, the baseball cards, and there were highly classified documents in there that contained some of the nation's most sensitive information. Oh, I'm sure. Now, the law required those documents be collected. And my question is, what law? Were those congressional statutes? Were those Congress? Did Congress pass those things? Were they constitutional amendments? Because I'm not aware of one. If there is, then I'll readily concede. Documents or I guess whatever Congress said in the statutes or whatever the amendment says. But that does not happen. Now, and the record is and this is new, right? Okay, no president has had to address this before because no government prosecutor has been insane enough to go after them. But that's what happens when you're dealing with Trump. They'll pull out all the stops if they can. So they say the record establishes that relevant government officials performed their tasks, and they did it with professionalism and patience as well, in the face of unprecedented defiance from Trump because he had his documents. So to develop its counter narrative, they say that Donald Trump and the defense, they cherry pick exhibits and they selectively quote from documents. But selective quotations coupled with speculative leaps do not make genuine factual disputes. And we're getting into some redacted territory here. You know how much we hate that. But they say much less, contrary to their claims, we don't need an evidentiary hearing on this, Judge Cannon. Please don't make us come back here. The storyline that Trump seeks to develop is contradicted by the full text of the documents, and the account that follows corrects the misimpressions. He's setting the record straight. I'm not going to be talked to that way. Okay, Jack. So here's what they say the background is. It's the removal of presidential records. And what's so fun about this is they cite the U.S. Code, right? U.S. Code right there. Again, is that an amendment? I don't think so. The genesis of this case dates not to May 2021, where they say it begins, but to the tail end of the Trump administration itself, at the conclusion of which the archivist was to assume all the presidential records from the administration. All right, so it's like about baseball cards. I'm not joking. We're going to see it's about letters and stuff, all right? It's pathetic. So then they redact this whole paragraph, and they cite the U.S. Code, saying, oh, it's U.S. Code, so that's the law that Congress passed. And I say, okay, well, that's nice that all presidents have complied with this presidential records crap. But if a president doesn't want to do that, Congress cannot usurp their right to their opinions in writing, as the Constitution says. So we get a redacted thing and probably something about this person had some concerns about whatever. Based on discussions during the administration, Worm Official 1, White House Office of something, Worm Official 1, believed there were 24 boxes at the White House residence. Now, to minimize confusion, they're saying we're going to 14. Okay, fast forward through that. Now, they say here, another U.S. code, the United States shall reserve and retain complete ownership of the presidential records. Under the law, NARA's task was to retrieve them. So NARA has an obligation under the law. They have to go get it, or else their library books are going to be overdue. No discretion at all. The laws of the law. No one's above it. So then NARA communicated about the missing records. They said, we're missing some baseball cards. After circulating a draft letter within NARA about the records, NARA wrote to Trump's representatives. The letter expressed concern. We're worried. We cannot account for the records, and we need your immediate assistance. As they're all setting this up, they're going to get Trump on a process crime or a paperwork crime. So these missing records included several prominent documents. Oh no. Like what? Like what? What do they need to wreck the fabric of the country for, just to make a point? Guess what one letter was? Oh, it's a letter that former President Obama had left for Trump in the Resolute desk. That's it? That's the big concern that we're all worried about here? White House Office of Records Management. Worm. Yeah, they're worms for this one. So the Resolute desk, okay, Obama leaves the letter. You've seen this tradition. Everyone leaves a letter for the incoming guy. Trump said, that's my letter. He wrote a letter to me. I'm the president. That's me. And the letter Trump received from North Korean President Kim Jong-un. Another letter and a poster board showing that the path of Hurricane Dorian that Trump had used during a televised briefing. Those are letters. Are those even classified records like at all? Like, is that even within, I would say that's just a personal letter. So why can't Trump just take that, right? And here's another letter, personal letter, that Trump got from Kim Jong-un. Wow, national security, we're all going to die. Trump took a letter. A poster board showing the path of Hurricane Dorian. The letter also noted, so NARA's flipping out, right? They're sending this letter. We need immediate assistance. We cannot account for Obama's letter to you. Ah. So they're freaking out, right? These are government bureaucrats. They're having a meltdown. And they say there are 24 boxes that were never transferred back to our library. Trump took his baseball cards with him. And so a month elapsed, right? They're all panicking. Ah! A month. This is Jack Smith admitting this. This is not Trump's writing this. What? Letters? This? A month elapsed without progress on the missing boxes. And the archivist, after a month, he sent an email. He said, I'm out of patience on June 9th. I'm out of patience. Now, the PRA, the Presidential Records Act, permits a president to designate representatives. Trump appointed 6 representatives, 5 were attorneys, and they were not, given the PRA representatives' delay and their vague assurances that we're going to resolve this soon, that was an understandable reaction to the foot dragging that prevented NARA from fulfilling its statutory duties, okay? So some whack job bureaucrat, and I still want to know who this was, the leading archivist. I'm out of patience. Trump won't give us the Obama letter back. So we have a statutory duty. Okay, their lives are so meaningless. Like they have to get their books back. Okay. As NARA attempted to carry out its responsibilities, which this is, every time they say this, it's kind of like, it's really like, that's like their biggest problem right now is to go track down stuff from Trump. Now, it was unaware that scores of boxes will remain unsecured and that those boxes contain classified documents. So then a bunch of Trump representatives corresponded with NARA and they never resolved any of NARA's concerns. They say, we want those boxes back. They say, you can't have them. Those are my documents. They're not even, that's a letter from Obama to me. Get bent. Not even a government document. All right. It's a personal letter. Get out of here. So get out of here. Now, by the end of June 2021, NARA still had received no update on the boxes. So they're pounding the door. Those are our letters. We love Obama. You don't get to keep that, which I think most of this is probably spite. Like, you don't get to keep that. That's not yours, right? Think about what the conversation is with these archivists. He has no right to do that. And they're sitting around and the law says that we can do it and he can, and they're just, finding ways to go get him. So then they inform the representatives that the archivists, so it informed Trump representatives that the archivist had directed personnel to go to the DOJ by the end of June. We haven't gotten our letters back, so NARA refers it to the DOJ, and they say this is necessary when we're unable to obtain the return of improperly removed government records that belong in our custody. So it's NARA, they're our baseball cards. You don't get to keep Obama's letter. That's ours. And they want to keep it, probably from Trump just to be spiteful, if I could be honest about it. Like okay, to preserve the records. First of all, are they going to publish that? Are we going to be able to read that? I don't think so, right? That's all going to go under lock and key, I'm sure, unless they both consent to releasing it. But that's like a private letter, right? I would actually, imagine that it stays private. Like that's a private, president bro code. Like don't, that's our bro code, bro. Don't bro us out. So providing the archivist, so they say, we want the Obama letter back. Now that message saying we're going to the DOJ, it precipitated the involvement of White House Chief of Staff, Trump's former White House Chief of Staff, who engaged the archivist directly at the end of July. And so presumably that's Mark Meadows. Now, additional weeks passed with no results. By the end of August 2021, NARA still had received nothing from Trump or his representatives, and they're flipping out now. That's our letter. Independently, the House of Representatives, don't give us that crap, that's Liz Cheney, had requested presidential records from NARA. Okay, we're in 2021 now. J6 Psycho Committee is in full swing. Further heightening the urgency. So you see what happened now? It's all rigged. So NARA says we want the Biden, the Obama letter back, or else we're going to flip. Then the January 6th committee, they start pounding the table because they're a political show trial committee. Okay, it's not like an investigative committee. It's a political committee that's going to create political dirt. They start pounding on NARA's table. Hey, go get the documents. We need them. NARA says, well, we can't get them. They go to the DOJ. So then on August 30th, the archivist notified Meadows that he would assume the boxes had been destroyed, and he would be obligated to report that fact to Congress, the DOJ, and the White House, which honestly would have been a better solution for Trump. Okay, he could have just done what Hillary Clinton did and just had everybody delete everything, like literally smash cell phones with hammers, which they did, and delete evidence using software evidence to delete it called BleachBit. And Hillary Clinton gets asked about this, what, like with a cloth? Okay, so they're beating Trump up over these stupid letters that are meaningless and his. And then they've turned this over. We're going to have to get everybody involved, FBI, DOJ, and the White House. Okay, we have to tell them. Meanwhile, Liz Cheney's pounding on their door. Now, the former chief of staff promptly requested a phone call with the archivist. He's like, hey, stop being a lunatic. So apparently there was a phone call. So the formal and limited involvement of the White House counsel's office. How about that, Jack? Hey, Jack, why'd you redact this section, huh? All the rest of this we can read. But the one section that we got concerns about, so archivist is now being pressed by Liz Cheney, and the White House counsel now gets involved. We don't know why. What brought them in? So someone notified them here, all redacted. Who notified the White House counsel and what did they do? And don't tell me it's limited involvement. There's a full paragraph redacted. So then Sue was subsequently included in correspondence with Trump's representatives and NARA. Now, Exhibit 6, but not for any nefarious reasons. So why was White House counsel Sue jumping in? He just did it to help, not for any nefarious reason. Trump says it's because he's from the White House. No. Rather, they say before his call with Mark Meadows, Worm Official 1 wanted to review the notes that he took during the Trump administration on the missing records. So it's just like a notes. These notes had become records and in NARA's view required the notification to Trump or one of his representatives before Worm Official 1 could see them. So any doubt about the reason for Sue's involvement is resolved by an email. There's nothing nefarious here. In early September, a Trump representative who has served as the deputy White House counsel proposed to NARA the idea of a conference call with the Worm officials, the records people, Trump's former chief of staff, and others about the missing boxes. Now, as NARA wrote at the time, he and Trump both understood that they would have to coordinate with the White House counsel regarding any involvement of Worm Official 1, the records person. Accordingly, the NARA official then spoke with Jonathan Sue, deputy counsel to the president, to let him know about this. So then Sue reached out to Trump and set up the call. At no point did anyone suggest that this was proper in any way. And again, this is not what actually we're talking about. Like, this is just a random phone call. Thanks for setting up the phone call, Sue. So they went in, they identified one thing that Sue did that was like above board. Oh, he just set up a phone call and showed some notes. They put that in the motion. Great. What else did he do? That's what we're concerned about. So they say Trump is also misleading. Like, thank you for giving us one example of he just was set up a meeting. Thanks for that. Now, the defendants also misleadingly suggest that there was something improper about his involvement in the discussion of whether Worm could review the notes. But in fact, not only did Trump's people know about this, but they told Sue and NARA, and they approved it. They said in connection with our call yesterday, Worm was going to get his own documents from NARA so he can check his call and talk to Meadows about this. Sue then asked NARA if they could discuss process in the event that they asked to see the notes himself. They said normally we would have to provide the records to him. Now, far from alerting that Sue that the request was atypical, this is all normal. Okay, thanks. They say in no way supports the claim that the White House was exercising undue influence, right? That's the allegation. Is that the White House counsel and that Joe Biden were essentially goading Merrick Garland and the DOJ into bringing charges. And Joe Biden said, we're going to use any mechanisms under the Constitution to get this done. And then he was very upset. New York Times had an article about this, that Garland was catching flack from him. And then suddenly charges came. Now, they say Trump also points to another internal email chain. So they're just explaining the Trump evidence, right? They say that description mischaracterizes the email. It's unfounded. NARA's statement was that we plan to let Trumps know that what we plan to do. Earlier email chains also guts their claims that NARA was eager to involve the DOJ. Why? Because they said, well, we cannot go to the DOJ while we're still talking with Trump. They said, we can't go to the DOJ while we're still talking with Trump. So the record shows, right? They give us this one example. The record shows that NARA, the baseball card librarians, was taking a cautious, incremental approach that aimed to achieve the legal compliance without litigation, right? So they paper their file. They say, well, don't go right to the DOJ. We can't go to the DOJ when we're talking with them. Now here, time goes by, and they're still correcting the record. We haven't even gotten really to the substance of the motion. But they say fall passes, and we still are missing the Obama letter. In September 2021, one of Trump's representatives expressed puzzlement over the suggestion that there were boxes missing. So in an effort to resolve the dispute, NARA officials discussed with Sue the possibility of convening a meeting with two of Trump's representatives. On this date, a call took place among records and another employee between Mark Meadows and other deputy White House counsel and Sue about the continued failure to produce the records, but didn't lead to a resolution. They're not your records, they're ours. Again, there was no complaint for Trump about Sue's participation in the call. Redacted, 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 redacted. Well, that's because they hadn't been directed to be indicted yet, right? So that's probably why. Now, some 2 months after that, nearly a year after he left office and more than 6 months after NARA requested them, then Trump delivered the boxes back, 15 boxes back over to NARA. But Trump knew that there were dozens of boxes that they wanted, and he provided no more to NARA. You can have those back. Those are yours, fine, but these are mine. Now they say, finally, Jack, finally, our 15 boxes come back to NARA. So the Trump truck from Mar-a-Lago completed its journey on January 18th. A NARA official was on hand. He's like, finally, our cards are back. I can sleep easily. But they reviewed the boxes and they discovered documents with classification markings on them. Huh? So-and-so did this and so-and-so. And this is when it all broke down. Now, his review of the boxes revealed at least one that was an SAP, referring to a special access program, which is highly restricted. Now, the shifting accounts of the number of missing boxes, redacted here from someone, and someone, raised concerns about whether any comprehensive search for these records had been done yet. So NARA's like, perfect. We now know he's got something he's not supposed to have. Let's get everyone involved. So redacted here, don't know what they're doing, flipping out, calling, so-and-so. And then they say, this decision was entirely consistent with the statutory role of the Attorney General to get missing records. Okay, so whatever happens here. Now he says, perfect, U.S. Code 2905A. We're entitled to just go do whatever we want. And this was appropriate given the national security threat of the classified records. And they're outside of government safety in the hands of a former president who had no authority to possess them. And so now we're back into actual, classified documents. And then we go back to the opinion clause, which has not been settled, right? That is a case that has not ever really, I think, been tried or litigated. But for their part, they say the ODAG officials, so the Attorney General, they instructed NARA to notify both the Inspector General and the Inspector General for the intelligence community and other officials who were in charge of overseeing these things, notify them. Referrals to offices with authority to consider the security concerns that were prompted by the revelation, again, was entirely appropriate. We saw classified documents. We all sprung into action. And we started an investigation. And so all that investigation was absolutely justified. And why? Because dozens more boxes and hundreds of classified documents were recovered. And so then, and only then, after they got the Obama letter back, then they made a referral to the DOJ. On Feb 9, NARA then made its formal referral to the DOJ. Our library books must be returned. That referral, again, entirely consistent with a longstanding interest in saving the country. Now, as Trump has stated, Trump has said this before. He says no one's above the law. So I guess they're using one of Trump's quotes against him. Very clever lawyer. Well done. Now, the defendants nonetheless label this referral a sham, saying all of this was concocted to go create a crime against Trump. Now, the defendants did not explain what a sham referral might be. Well, you just did it, basically. Much less what legal significance it might have. But their contention is grounded in a timeline of events which shows communications between NARA and the DOJ about a congressional inquiry. So in other words, Liz Cheney says, I need it, pushed pressure on NARA. NARA says, we'll go get it for you. NARA can't go get it. Then when they can't go get it, they refer it to the DOJ. Okay, that's the chain. Cheney to NARA to the DOJ. Got it. Followed later in the day by the referral. They say it remains a mystery why the conjunction of those events is suspicious. Well, it's because Congress is a political body, right? And they're not an actual executive branch agency at all that's supposed to be fair and impartial. They're partisan congressional hacks. That's why. So if Liz Cheney and Benny Thompson are the ones that are driving this, that makes it biased, obviously. Now, the concerns, and I'm not saying that NARA or the DOJ is without fault there either. Obviously, they both are. They all wanted this to happen as well. Now, the concerns about Trump's retention and the dilatory responses had taken months, and DOJ had responsibilities. And so the Office of the Inspector General had an ample factual basis to make a referral, and so we could do it. So this is not a sham. And by the way, we all know that you could indict a ham sandwich, right? That is a phrase that you often hear in the law because it's true. You can make up a crime for anything. And if you say, Rob, that's ridiculous, just drive around the block. Just go to work. If you had a very motivated cop who is following you on your drive to work, he could pull you over every day for something, right? Whatever you do, whether it's following too close, an unsafe lane change, a merge problem. You can stop in the line in the park walk. You can make a wide right turn, a wide left turn. Doesn't matter. Pull you over, basis for something. You look like you're under the influence. Arrest you, whatever. Even if you have nothing in your body, right? There's no consequences if they come back zeros. They just go on to the next one. So my point is, they can make it up for anything. And they just happened to do it against the president. They really needed to paper their file to make it done, but they did it. So they say far from being a sham, even though most criminal prosecutions, maybe not most, but a large part of them are shams. The referral became necessary after months of efforts. We worked hard to get these baseball cards back. Now, including several rounds of communications, and it failed to confirm that Trump had returned what we needed. And now finally, they say, this is Jack Smith still whining and moaning. Now finally, Trump also suggests that a NARA official sought to evade and later violated the Presidential Records Act when the FBI interviewed him later. But the full text of the interview dispels his nefarious accounts of the selected excerpts. Saying, block quote there, we'll fast forward, but rather than evidencing an effort to circumvent the Presidential Records Act by the NARA official, the NARA General Counsel, the FBI, or anyone else with complete picture reflects a careful effort to just comply with the law. We're trying to provide accurate information to the FBI, and we're not trying to alert Trump about this because he's under investigation. And so NARA complied with these objectives. They refrained from describing to the agents what the doc said. The inventories he provided to the FBI were also an exercise in caution. And so all this was entirely consistent. Now, the investigation ultimately led to the indictment. We know how that worked. From the moment of the referral, our investigation was measured. It was graduated. It was very, very, simple. Each investigative step revealed facts confirming the suspicions or the concerns that prompted it. Now, in light of NARA's discovery of more than 180 documents that had been stored at Mar-a-Lago prior to their transfer to NARA, the DOJ understandably sought to ensure that there were no additional classified materials there. So on May 11, 2022, a grand jury issued a subpoena to Trump, sought the documents with the classification markings. Trump responded on to that subpoena. They turned over to the FBI 38 additional documents confirming what others had suggested, what other evidence had suggested, that the prior production was incomplete. And then they got more documents back. So then the FBI agents visited, right? They went there. FBI agents noted surveillance cameras when they went and showed up there. And this is all part of the investigation, right? Like Trump's compliance here, I think is giving, like they're actually actively investigating him, right? it's almost like a drug buy, like literally. You want to buy drugs a couple times. And the first buy, you don't want to bust them, maybe not bust the undercover guy. First buy, you don't bust him on that because you want to know where he's getting them from. So the 38 documents, oh, perfect. Let's just keep him going. So Trump thinks he's still negotiating with them, right? So he invites him back over to Mar-a-Lago. Everything's secure. He had a skiff there, but he showed him the storage room, including where other classified documents were. In June, the grand jury issued a subpoena then for camera footage. Now, a review of the footage, combined with other information obtained during the investigation, revealed that Walt, acting in Trump's direction, moved 64 boxes from the room to another room and then moved boxes back around. We know that story. Now, at that point, the government had evidence saying that there was a deliberate effort to conceal boxes from Trump's lawyer's search. And that's actually their interpretation of that, right? There are some people saying, and I think Trump's defense is saying, that they're moving the boxes around so the lawyers can see them and so that Trump can see them, right? Trump is reviewing them and then, disposing of the boxes, in other words. But it's not an effort to conceal the boxes. They're moving them because they're processing them. In effect, thwarting compliance with the subpoena. They say, so therefore, now they're hiding evidence. So you see that, right? They show up. They don't take his word for it. They find surveillance footage, cameras. They subpoena that. It's just 1 inch. It's like the drug dealer invites you to the house. Okay. Then you start looking around. What else you got here? I'm going to investigate that. Right? They're treating him as a criminal from day one, from the very beginning, in order to set up the crime and charge him with it. So, he's not complying. Guess what? We have no choice but to seek a search warrant. You have plenty of choices. You didn't do any of that stuff with a lot of other people who had their classified documents. Now, they say it's because Trump is not complying with them. And our take on the government from the Trump position, he's entitled to those documents. And they can litigate that. But anyways, so execution of the August search warrant includes the use of filter personnel. A bunch of people came in, looked through the documents. They executed the search warrant back in August. We were here, covered the raid. They got Melania's underwear and all the things. And they had a taint team to come in here and say if it was privileged, then we'll separate it out. But they still found more classified documents. But even then, no indictment immediately followed. The government undertook careful investigation. We interviewed a bunch of people. We executed search warrants. And then we decided we have no choice again. We're out of choices again. We sought information. We issued a subpoena for the originals. The government sought information, and we followed protocols. At no point did any of these entities or other of these people actually become a part of the prosecutorial team. And so finally, we're getting to a little bit of substance here. The argument is about the size and the scope of the prosecution team, and it's about compelling discovery. So they just described a bunch of other entities that were involved, right? Including these entities, DOJ, Office of the Attorney General, White House employees. But they say that they didn't participate in the investigation or present any of this case to the grand jury or accompany prosecutors or help develop prosecutorial strategy, so they're all outside of the scope. And only once our investigation uncovered that Trump had secret military invasion plans, and he showed them to others, apparently. And we heard that audio recording. That he was well aware of what was in the boxes, that he had directed the movement of his boxes. They say to conceal. I say no, just to move them. He had suggested to his lawyer after the review that the lawyer remove the damaging documents and not turn them over to the investigators. Well, because he says they're his. He had sought to have surveillance cameras footage deleted before it could be turned over. And the investigation also revealed the involvement of other people, their attempts to conceal the indictment as well, to conceal the footage as well. So on the basis of all those facts, and nothing that they made up, they returned a 38-count indictment against all the people. Now, following the indictment, the government then began producing discovery, finally, that exceeded the scope. Okay, so after he sets the record straight, hope you feel better about that, Jack. But he says, we give him everything that you needed. For example, during the investigation, we recorded nearly all of our interviews to ensure complete and accurate records. And we've given them all the recordings and all the transcripts. And we've also produced transcripts about separate interviews from all this thing. We've given 1.28 million pages of documents. And so finally, they're summing it up like, gosh, thank you guys. Good Lord. We're on now 19 pages of a kind of a rambling, screed there. We did everything right. Summing up as the exhibits and an accurate timeline attest, Trump's narrative overlooks the fact that various federal agencies confronted and appropriately responded to an extraordinary situation resulting entirely from Trump's conduct. NARA first sought over a protracted period to get the documents back, and Trump was dilatory. We attempted to carry out these things, but these documents were in ballrooms, in bathrooms, and other locations. NARA rightly involved other government agencies, and we want the discovery from those agencies that had equities and authorities that it did not. So they went and got it. The White House counsel's office, they became involved because of the need to consult its personnel about missing Trump presidential records. That's the only reason the White House got involved. Because you're at the White House and we need to talk to somebody at the White House. Did you check the closet back there? Yeah, go look in there right now. Are there any boxes? No, in the back. It's deep, like in the back. Move the coats aside. Yeah, back there, up there. See any boxes in there? Oh, okay. That's it. That's the only conversation with the White House. Everything else is just normal. Yeah, right. Now, the DOJ also became involved because the Attorney General's authority to retrieve the records was all warranted, all well outside. So, other people were needed to be brought in to go do the things in order to indict him, which is a lot of work. Like, it's a lot to bring all these people together. They really were motivated. And the intelligence community, they became relevant because once we knew it was classified, then we knew, oh, it's classified. We better talk to the intelligence agencies. So none of this is surprising. None of it supports the claim that we're entitled to get more discovery. They don't even make that point. They say none of this is politically motivated operatives, and none of this is a crusade against President Trump, which to me, it reads exactly like a crusade against Trump. One after another, they're orchestrating a way to ensnare him so that they can charge him with crimes over documents that started with Obama's letter. So here is their actual argument now. So we're now on page 20 of 67. All of that was really kind of irrelevant to everything we're talking about. If you read through Trump's original motion to compel, which we did here, there was not 20 pages of verbose garbage from Trump's people. They just kind of jumped right into the argument. This is why we need the discovery, because we're criminal defendants in the case. The government has the possession of all the materials, due process, and case law supports that. We have a right to see the evidence that when we're accused of crimes. And as you admit here in your own filings, that includes a bunch of people. It includes NARA and all these other agencies because they were all colluding with each other in order to make this happen. So here is finally their argument. It's like, gosh, finally, after your 20 pages. So they're responding to Trump's claims that he needs CIA stuff, he needs Secret Service stuff, he needs more DOJ stuff, he needs more FBI stuff outside of the small teams. And they say he doesn't need any of that. Here, Trump moves to compel us to disclose various things. And they group these into 6 main categories, and we're going to talk about this below. They say each of their discovery requests fails because it cannot be grounded in speculation or conjecture. Most of the motion to compel is devoted to their request for discovery to support their unfounded allegation that this thing is tainted, of course it is, by political bias. And they just spent 20 pages trying to refute that. But still, they seek information that is being held by non-investigatory government entities. They're saying these are just like record-keeping agencies. They didn't do the investigation, and so therefore you're not entitled to this. And also, this stuff is barred by work product and deliberative process doctrines anyway, so you're not getting it. And they say the extensive discovery that we've already given to you is everything that you're entitled to under the law. Trump, you're not permitted to wide-ranging irrelevant discovery. And one additional point they say, Trump, he begins his argument section of their motion with a broad abstract and a request that the court define the prosecution team for discovery purposes. But he does not citing anything to support that request. And the government has already explained that our team is very small, right? The government wants their team to be like 6 people. The prosecution is the special counsel's office, the law enforcement officers of the FBI who are working on this case, some people in the Washington field office, and the Miami field division. That's it. Trump says no. It's CIA, it's DOJ, it's Inspector General, it's NARA, it's everybody else. It's not just those people. It's the rest of the FBI too. Now that definition, they say, is just standard practice. Now their broad brush, undifferentiated approach would sweep the so-called prosecution team into all of the other agencies. It would really expand the size of the hula hoop. And this is wrong factually and legally. And this court should reject them. They say, look, Rule 16 only requires that we actually give them evidence that falls under the rule. They got to be specific about this. It's got to be material to the defense. Brady also talks about evidence within the prosecution's control, right? So they're going to say, we don't control the CIA. We don't control the Secret Service. We can't go in there and get all that stuff. More law here explaining the Brady Doctrine and so on. But we're going to get into the actual analysis here as soon as they finish with their copy and pasting. Now, here is, again, all this is rules. Now we get to discussion. So here is the analysis. They say, now applying all of those principles, they say Trump does not get discovery. Their request to compel us to give all of this to them should be denied in full. Here are the 6 categories, and let's go through them one after another. They say 2 of the categories of information sought should be rejected, specifically any evidence about improper coordination with NARA and the grand jury process. We don't want them to have that information. Why? Simply here, because NARA, the White House, and the intelligence community, none of them are a part of the prosecution. And any items that they may have are not in control of the government. And the government is very narrowly defined for the prosecution here. It's not like technically, yeah, like CIA is the government, but not for the purposes of this case, they're saying. To be clear, their requests are also predicated on a false narrative. They say the investigation and the prosecution of this case have been appropriately driven by the facts and the law, not any form of political bias, which is like, LOL emoji right there. But the question at this juncture is whether Trump has met the standards to get us to be compelled to disclose this material. Talking about the different standards that need to be met, and there is a entity by entity breakdown here. And so let's just fast forward. Here we see. Now they say here the government has already given everything that we have from NARA, but they still ask us for NARA stuff. They want all notes and everything from NARA, but it's not clear what they even want. They're apparently talking about reports, notes, and communications, but these requests should be denied. NARA is not a part of the prosecution team. Prosecutors here did not and do not exert any authority over them. And NARA is not an agent of the prosecutors. All they did was collect 15 boxes before any criminal event has occurred, and then the DOJ commenced a separate criminal investigation, and NARA was not involved in any of that. One of their requests is to compel the disclosure of 81 documents that were compiled by NARA. They say the government already reviewed those documents, and only 15 of those matter. And so the mistaken claim distorts the innocuous event by saying there's a government-wide scheme to target Trump. And they say, no, there is not. Now, here's the White House as well. We want all the evidence that the White House was communicating with NARA, the National Security Council, the White House Counsel's Office, the White House Office of Records Management, all of those agencies. We want to know what they said. But none of those agencies, they say, played an investigatory role. Maybe they were like sending emails and stuff, but it was all just process. Prosecutors have no authority over the White House or their constituents. They've never served as our agents. No personnel from the NSC, White House Counsel, or ORM participated in any interviews other than as witnesses. They didn't play any role in the prosecutorial strategy. And so therefore, the White House was not and is not a part of the team. And any arguments to the contrary lack merit. It is not a causal relationship. And it conflates communication with coordination. So yeah, even though the White House was talking back and forth with the prosecutors, it was just an investigation, and it was not joint participation, and there was no authority-based relationship. So they're not a part of this. Same story here. The intelligence community, they say they want the materials from the Intelligence Community Ombudsman, Dr. Barry Zaloff. They say first, like the White House, the intelligence community is not a part of the government. There's no case law to support this idea that he's been victimized by criminal conduct by the government. And here, the IC also played no investigatory role in any of this. Third, prosecutors don't have any control over the CIA or any of these other entities, including the DoD, the CIA, and elsewhere. None of the factors support finding that the IC was part of the prosecution team. Intelligence community members were not under any obligation to share any of this stuff with us. And in other words, it was kind of voluntary. So, nor, they say, are Trump and his team correct that prior government filings conceded that they played an integral role. So you could make the argument that, well, somebody needs to come in and verify that it's classified. I mean, if it can't be confirmed to be classified, then it's not an illegal document, right? So somebody is going to be a part of that analysis team. Now, in opposing a request for a civil injunction, a declaration filed simply underscored the importance of the FBI working with the intelligence community, but that doesn't mean that they were part of the same prosecution team. So they communicated back and forth with one another, but that doesn't mean that they're part of the team. The role that the IC played at the outset in determining the nature and the scope of the risk did not render them part of the team. So yep, that is classified documents. It is going to, wreck the country or whatever. It's a threat. That's all, which is pretty material to the team, right? The prosecution team, I think, can't really prosecute without that little fact. But they say it's too far removed. But the already produced documents render all these other requests moot, and so the IC is not included. And finally, special counsel, DOJ, as well. So we'll conclude here. They say the court should deny Trump's request. We've searched for everything. The defendants assert that the government must search the Scattered Castles database, which is something that exists. It's a database of security clearances that are maintained by the IC, and a similar database maintained by the DoD. They say the government has already searched this, and we have no security clearances for Trump. And the government made requests to the DoD and elsewhere, and so security clearances are moot. We already searched for those. And we don't have those. Trump does not have security clearances. And so they say the Department of Energy is also not a part of the prosecution team. And you should also deny Trump's request for evidence that were related to securing his facilities. They say they also want evidence about the use of secure facilities at Trump's residences. But the court should deny these requests for two reasons. First, they say in response to grand jury subpoenas, the Secret Service already provided materials to the government which have been produced in discovery, noting, among other things, they've already given all this over, guest access procedures, diagrams, maps, and so on. And the government obtained via subpoena email accounts of 3 Secret Service agents. And they talked to the Secret Service people too. In short, the government has already given all the documents, everything that they need. Now, if they want to compel us to do it, this is nothing other than a fishing expedition. All of everything we've disclosed is justified. And so we'll fast forward through this. You can see it's just going on and on and on. Deny, deny, deny. Everything that was in Trump's letter, they want denied. Here in conclusion, they say, for all the reasons set forth below, deny. And I think they missed a word. Conclusion. For all these reasons, the court should defendant's motion to compel in their entirety. Man, don't you hate that? You spend 63 pages writing a rant, and you forget to include the key word, which is deny. We'll add that in the red lines. These are government prosecutors, okay? You can't expect too much of them. So deny, okay? The court should deny defendant's motion to compel in their entirety. And that is what Jack Smith sent in. So I think that there is some likelihood that they'll be successful, actually, right? The scope of the prosecution is something that they want to narrow down. So, they want it to be very small. Only be required to disclose this information alone. But this is what Trump wants, all of this extra discovery. Now, what's likely to happen here is the judge might split this a little bit. Okay, so this will be no, this will be excluded, but maybe they expand it a little bit so Trump gets a little bit more. We'll see what the judge ultimately does. And Trump will submit a reply to this, by the way, as well. So this is a response. Trump is going to get the final last word. He'll submit a reply, and we will see what is inside. But Jack Smith spent a lot of time kind of explaining himself. I mean, he doesn't like the implication that his government agency, his office, is filled with partisan hacks. But they are. In fact, this is what former partisan hacks like Andrew Weissman, who, still partisan, but who used to work at the DOJ, this is what they say about the fact that Trump is not being prosecuted fast enough. So this is now talking about the DC case where Jack Smith is also trying to get the trial back on track. He submitted a motion, or a series of motions have been submitted saying that Trump is immune from these charges. It's currently at the Court of Appeals. If the Court of Appeals continues to delay this thing, that creates more time that Trump gets once the trial is back on track to prepare his defense, which means it's going to postpone this trial later into this year. Now, if it goes far enough, the question is, can they get this trial back on track? Because Trump is still going to appeal this to the Supreme Court, and there will be other issues as well. And they are hitting the panic button. They're hitting freak out mode. In fact, this is MSNBC's hit show called Inside Jen Psaki with former White House Press Secretary Jen Psaki. And she's here with Andrew Weissman and Neil Katyal, I believe, both former DOJ people. And here is what they're feeling now that the Trump prosecutions have been, a little bit slower than they're liking.
So, Neil, let me go to you, because Andrew raised a really important point here. I mean, that this is normal pacing here. As much as we're all impatient and as much as it's not aligned with the timing, give us a sense of what else could be going on behind the scenes here in your assessment. And if this is not this is not move forward soon, I mean in the coming weeks, could the federal election trial start in June, July, and still be concluded before the election?
August?
It could. I mean, my view is that actually the normal schedule for an appeal of this magnitude with these types of public interests at stake would have been that this case would have been decided by now. So I understand, like an ordinary garden variety DC circuit appeal, it takes longer. I think an average disposition time of about 6 months. But in a case of this gravity, it should be moving more quickly. Take, for example, when the Court of Appeals for in the South reversed the Judge Cannon's decision last year to protect Donald Trump. It took them, I think, 9 days. And so, to use your phrase, Jen, at the beginning of this show, I am officially now at the freakout stage. I've resisted that for a long time, but we are now.
You don't typically freak out, so that's important.
Right. Yeah, no, I think we're now at the point, to use a different legal phrase, justice delayed is justice denied. I mean, I can't imagine a more compelling need for speed than the idea that American citizens deserve to know before the election whether a candidate for office is a felon and an insurrectionist. And it's
They need America to know. And they need a Washington, D.C. jury box to tell them, to tell them clearly, Trump is an insurrectionist. And they got to go now. I mean, he doesn't really care about Trump's right as a defendant or things like, the presumption of innocence or due process of law, right? The right to a speedy trial is recognized for the defense, right? The defense doesn't want to be thrown into gulags like the J6ers. But the point is, the general public interest in prosecuting Trump because these guys are salivating, at the jowls on this thing, that's not a real good legal argument. Like, we know you're freaking out, man. I'm freaking out, man. Ah! Relax, okay? It's just law, right? Relax. And it's your people who are doing the steering on this. Sorry, it's not going as fast as you'd like.
It's even more galling to me because this is an easy case. There is no responsible constitutional scholar who thinks Donald Trump is right, that there's an absolute immunity, that a president can go and order Navy SEAL Team 6 to go murder his political opponent and then go and murder the senators who would try him for impeachment.
What kind of a psycho argument is that? Okay, if that happens, the country's in a pretty bad spot, right? If we have half the Senate being taken out. If you have people who are following those orders, right? The country's in the middle of a civil war. And that's the whole system has failed, Neil. But it's the only real analogy they've got. And, if a president orders an unlawful execution, like, for example, like when Barack Obama killed American citizens via drone strikes, the Senate really has the opportunity to then impeach them if that is really a problem. And apparently they thought that was okay that Obama killed citizens, whatever. That
cannot possibly be right. And Judge Chutkan set a fast schedule here. And I have no idea what the Court of Appeals is doing right now. But I can tell you that I'm really worried that this delay is going to put the trial past June. It's possible that Trump will try and go to the Supreme Court after he loses on the Court of Appeals. Of course he will. That can take months. This is a real problem.
Judge Chutkan.
This is a real problem. It is a problem for you guys, man. And that's what you see, like they just are now talking about it openly. Like that's the whole thing was a political hit. And they needed to get it done before the election so that they could keep him off the ballot, so that they can use this as a cudgel to say he is a convicted insurrectionist. And by the way, right, if they get this done before then, and I personally believe that if Trump goes to trial on this in DC, he'll be convicted. Like the conviction rate for the J6ers is like 98, 99%, if not more than that. It's just a thing. So he'll be convicted. And then, my friends, then that's where the real psychoness begins, because they'll use that conviction, even though it's not a conviction for insurrection. These are all other obstruction charges and free speech crimes. But okay. But that will be the first domino for Crazy Eyes Griswold and Shenna Bellows and others to keep him off the ballot, right? They'll revisit all of the ballot removal cases because many of those were only applicable to the primaries, and they'll come back and they'll relitigate this back during the elections, and it's just going to get spicier by the day. But what I love about that clip is they're freaking out, man. They're freaked out. Like all of their eggs are in these baskets, and their cases are crap. Fani's getting weighted by Nathan, and in Florida, they got classified documents that are probably going to delay that trial. So they are just nervous as can be. It makes me happy. And so we're going to continue to cover this, my friends. No matter where you're watching this, we'd love it if you checked out watcherlodge.com. The links are down in the description below. We got events coming up in February. They're all free for the first 48 hours. So make sure you go sign up, register at watcherlodge.com for our events, because we got a lot of fun stuff cooking over there. And then we'll be back here, of course, to cover all of the Trump prosecutions, all the Trump trials, all the litigation as it unfolds ahead of us. Thank you for subscribing wherever it is you're watching this. Also, you can check out robertgovea.com if you want to access the PDF. Links are in the description below. We're going to cover this and more, and we'll see you back here on the next one. All right, my friends. Now, we are not done yet. We are going over to Georgia, and we're going to see what is happening with Fani and Nathan Wade. Fani Willis gets called out. We're battling for the case to be dismissed in the RICO filing in Georgia, and something has been going back and forth. We've been watching this brew for quite some time. The motion to dismiss the case and the motion to disqualify Fani Willis was responded to by Fani Willis, and we read through that filing in full, and she admitted, I had a personal relationship with Nathan Wade, but it doesn't taint the case. It's not a problem at all. In fact, it's so far removed, it's not even a big deal. But now what we see is a reply to Fani's response. And so remember the way this works. A motion to dismiss the RICO case, or subsequently a motion to disqualify Fani Willis. Fani responded, and then we get Roman's reply. And we're scheduled for an evidentiary hearing this week. We can't wait to get to it. So hopefully you're subscribed and you join us when that drops. But as a reminder, Fani Willis submitted this response, and we covered this last week. You can see our red lines are already on this filing, the docs at robertgovea.com. But Fani put this one out, 176 pages, and we read through the full thing here last week. But just to remind us about what was happening here, Fani said that there was no financial conflict of interest, no personal conflict of interest at all. Nothing justifies her dismissal or disqualification. And the big issue here was Fani said, we don't even need an evidentiary hearing. Okay, we don't even need an evidentiary hearing. We don't want to talk about this stuff in public. So Judge McAfee, you should just deny this right now. Now, Ashley Merchant, Mike Roman's lawyer, wrote a reply to this, and he's saying, oh no, we need a hearing, Fani, because I've got some questions for you. And she's calling her out on him. So we're going to see what she says. But they went through, just as a recap, they went through this filing and they just came up with a bunch of nonsense. They said, well, you know, Fani never murdered anybody, for example, and you can only be removed if you murder somebody. And since I didn't murder anybody, I don't need to be removed. Needs to be more than theoretical. Must be actual conflicts of interest. We talked about all those things. Fani was going on cruises after she was paying Wade $1 million. Okay, so she was getting some benefits from him being employed. She has the discretion to fire him or to not renew his contract, and then goes away all her money. So as you can see, there was a lot here. And Nathan Wade also actually submitted an affidavit. And so let's take a quick look at the affidavit, because he made some assurances, and all of this was signed off on by Fani's office. And they said that they had no relationship. Check this one out. While professional associates and friends since 2019, and put a pin in this date, there was no personal relationship between Willis and me prior to my time in 2021. Interesting. Now, Miss Merchant is going to have a question about that. We're going to see. But then in 2022, these two little lovebirds, they developed a romantic relationship, a personal relationship, in addition to their professional association and friendship. Now, I've got no financial interest in the outcome of this case other than being paid if you continue to prosecute it. If you, like, this is crazy, because if he dismisses the case, he loses all of his money. Okay, so he does have a financial interest, but you could say that about any prosecutor, I guess. Except this special prosecutor is specifically for this one case and getting paid $1 million to do it. No funds paid to me have been shared with Fani. And this one's another good one. I have never cohabitated, okay, with DA Fani Willis. I've never shared household expenses. I've never shared a joint financial account, and so on. This is them on the record. Now, to be honest with you, I don't care if two prosecutors indict each other in the privacy of their own bedrooms. Like, that's fine, whatever. But if there's a subordinate and supervisor relationship, obviously that brings in like HR problems. Like, that's a problem for, I think, many places of employment. Not any different here. That also begs the question about funding, right? She's giving him $1 million. So now we've got a conflict of interest there. We also have questions now about their integrity and whether they are lying in general about any of this stuff. And so I understand it does feel kind of salacious, right? If it's just Fani and Wade indicting each other, that's fine, in their own prerogative. But when it spills over into a nationally prominent case where we think that you're lying from the beginning, that there's no basis of charges in the first place, when we've got questions about your collusion with the White House counsel, and we think that you're being dishonest when you say that your communications with them were just process-based, or we say that it's dishonest when you're meeting with the January 6th committee. We've got questions about all of this. And if you're going to lie to us about this, we have the belief that you're lying about other things. And so it does, in fact, taint the whole case. It's not just salacious, divorce prosecutors, motioning to compel each other. It's a much broader problem with the DA's office and everybody who works there underneath. So that is the original filing. Now, this is what Roman said in reply to that. Michael Roman calls Fani out big time, saying this in his reply to the state's prior response to dismiss and disqualify Fani. And so just to back up quickly, Fani said, we don't even need a hearing on this. Just leave us on the case and don't call us into your courtroom, Judge. And she dropped this one. She says, no, not so fast, buddy. Comes now Michael Roman, Ashley Merchant, defense attorney extraordinaire from the state of Georgia, and files his reply solely on the issue of Fani and Wade saying that we don't need an evidentiary hearing. Okay, they say, don't give us the hearing, Judge. Please don't make us talk about this in public. And they also subpoenaed a bunch of people too from the Fulton County office. Please, can we avoid a hearing, please? Now, she says it is required, and we're going to make clear in this filing why an evidentiary hearing is required. Saying, this reply is not meant to be a comprehensive reply to the state's response. Mr. Roman will be filing a much more comprehensive reply that addresses each one of their arguments. Make sure you're subscribed for that one. And the initial reply is being filed now because the state seeks to have this court cancel the evidentiary hearing that is based solely on assertions in pleading. So I can't let that stand. I have to address that now. As we're going to show, an evidentiary hearing is necessary to test their claims, the assertions of the state, and there is no constitutional alternative. So we're looking forward to having you in the hearing, Judge, and Fani. We'll see you there. But here's what they say. Let us be clear. If Mr. Roman had not uncovered the now admitted personal relationship between Willis and Wade, no one may have ever known about it. And that raises the obvious and the important question. If they had nothing to hide in the first place because they did nothing wrong, why did they intentionally not tell anyone about it until they got caught with their hand in the cookie jar? Now, this highlights the very reason why this court cannot just take their word for it. They now attempt to escape accountability by asking this court to deny Mr. Roman the right to cross-examine and to test their assertions at an evidentiary hearing, going so far as to submit an affidavit from Wade that is inadmissible because you can't cross-examine that, and it's violative of the confrontation clause of both the United States and Georgia. We want to ask Wade some questions about Fani. And we can't ask him questions if he just wrote an affidavit down. So they are hoping that this court simply sees all the growing smoke cloud and says, no fire, nothing else to see here. Oh, here's our affidavit. Let's just call it a day. Thanks, Judge. Last thing we want to do is hear Nathan Wade and Fani Willis testifying. I cannot wait. Now, it's not that simple, they said. This is not a summary judgment motion. People's freedom and their lives are at stake. I've never heard it called a cookie jar before. Me either. That's from locals. Your hand in the cookie jar? What? Oh, all right. Notably, Wade's affidavit proves that a hearing in this matter is needed. Okay, Wade just wrote an affidavit, and that's not good enough. For example, if Mr. Roman was permitted to cross-examine Wade, if we got to ask him some questions, he could ask questions like the following. Here's some fun questions for Nathan. Hey, Nathan, in paragraph 17 of your affidavit, okay, you swore this under penalty of perjury, paragraph 17. You said that while presenting at a training course for a new municipal judge in October of 2019, I met Fani, is what he says. Okay, paragraph 17. Curious. It says you swore you met Willis at a municipal court training. Nathan, isn't it true that you began more than just a friendship at that conference? Oh! Whoa! All right, so Fani and Nathan, they show up to learn some training about how to handle a municipal court. And all of a sudden, we get some gavel activity, if you know what I mean. They're slamming that gavel on each other, Interesting. So a training conference, and lovebirds get together all the time and, things happen at conferences. But More than just a friendship. I wonder if someone has videos or photographs, these two making out, at the bar or something. Wow. So how about this one? Busted. Now, and sometimes you have cocktails at those things and things get out of hand. You're like, we're going to save this city. We're going to be the best judges. We're going to save Atlanta. Yeah. Isn't it true you began more than just a friendship? Ooh, someone else saw them, cavorting around that hotel. Hey, how about this one, Nathan? In paragraph 31, let's just take a look at it for full clarity. Paragraph 31, what did Nathan swear in his affidavit? I have never cohabitated with D.A. Willis. Ooh, this is going to be good. Let's see. In paragraph 31, you swore that you have never cohabitated with Miss Willis, but the attached documents show you shared a king-size bed with her in Aruba. Oh! I wonder if they had a suite or if that was overlooking the pool. From November 1, 2022 to November 4th, 2022. Hey, a king-size bed, man. How come they didn't get two queens? Two queens, they could share, cut down on expenses. They don't need to, saving Fulton County some money. We don't need two hotel rooms. Why don't you just come in here? We'll just get one king, baby. Yeah. So why would he lie in his affidavit saying he never cohabitated? They clearly were apparently, and maybe he slept on the couch. Maybe, I don't know. Busted. All right, here's another one. Man, I hope this just keeps going on and on for days, but here's a couple more. Additionally, witnesses, they're going to testify, Nathan, that you cohabitated with Miss Willis at her home in South Fulton until her father moved in with her and kicked you out. And then you began to cohabitate at the apartment of a friend of hers in East Point. Oh my gosh. They have them like totally busted. You did cohabitate, man. In South Fulton County. You were like there living with her. And then her father moved in and kicked your butt out. He's like, hey. Shout out to the dad, to Fanny's dad. He's like, first of all, you're not married, okay? This is disgusting. All right, you guys need to get your act together. Stop fornicating all over the house. Get back to work. You got to go to work, Nathan. Get out of here. Go back to work. So then dad comes in, throws him out. Fanny's like, why'd you do that to me? I love him, Dad. I love him. He's the one for me. He's like, daughter, will you relax? You're going to wreck your whole career. Just take it easy. He's my soulmate, Dad. You'll never understand. He's like, you're grounded. You're busted. So dad comes in, kicks him out. And and they got witnesses to this. And additionally, witnesses will testify that you cohabitated with Miss Willis at an Airbnb in Hattville that was paid for by taxpayer money to serve as a, quote, safe house for you and Miss Willis. No, that's just great. So they have a safe house lest they be attacked by MAGA insurrectionists who are trying to interfere with their love. Okay. So they also had an Airbnb. Okay. I don't know who they think they are, but all right. So that is not what Nathan said. Okay. That is not what Nathan said in his affidavit. So as you can see, it'd be nice to have him brought to the stand so we could ask him some questions about some of this stuff. The state's response also states that Wade has, quote, significant trial experience. Well, if his experience is so significant, then he should welcome the opportunity to testify as to the specifics of the cases that he's tried and enjoy the candid transparency that would bring to the process instead of hiding an unsubstantiated claim that he tried complex matters, including murders, rape, armed robbery, ag assault, and drug trafficking. So like I said, when we covered this, like if he's done murder cases, like that's a lot. Like that's like a trial, a murder trial. That's a big trial. It's like, well, okay, that's respectable. Now, what does that mean? Was he second chairing it? Was he on the team? Was he actually there giving opening arguments? This lawyer is skeptical. She's like, I know this dude. He's not doing all those things, because the defense community is pretty small, even in Arizona, which is, big. Maricopa County is huge. Small. Like when I was practicing, I knew all of the lawyers and knew how they handled stuff because like you get to see them in court. Like most of criminal law is waiting around in courtrooms, filing motions, talking to clients, and then waiting. And so then all the lawyers go in front of you and they handle it, wow, they handled that well. Oh, well, who the hell was that? What the hell did they say? And, you get to pay attention to it. And you learn a lot, actually, by the way, too. You can meet people, learn stuff, and solve problems. It's a lot of fun. But they say, this lawyer knows, this is not this dude. To put it plainly, he has given this court and the public no reason to take his word for it. Now, a hearing is also needed because it appears that DA's office is not being entirely candid and transparent as they allege. For example, the state attached to its motion Exhibit H, which is a contract that Mr. Roman has been asking for but never received. Erica Willingham, an open records officer from Fulton, responded repeatedly that she had given undersigned counsel all the contracts that existed, but yet this contract was not contained among them. And this creates important factual questions about whether Wade and Willis have been transparent that can only be resolved at an evidentiary hearing. So this is brilliant. She's obviously connecting this to the rest of their performance in the case. Like if they're lying to us about all this stuff, they're lying about everything else. And I've got some examples of this where they say they give us this record and they didn't. Saying included in the DA's response are pictures from Mr. Roman's counsel's Facebook page. And this is true. Remember, they put in this image of Ashley Merchant, and there's like a big dunk on her or something like that. They're like, oh yeah, Ashley Merchant supported Nathan Wade. So he's clearly experienced. Ashley looks great right there. Looks fabulous. But apparently this is her, right? Vote Nathan Wade, enjoying some Greek music while getting the word out. And my thought was, okay, you can be a municipal court judge and handle traffic tickets. That's no problem. You can be totally competent for that and qualified for administrative hearings and default judgments. Oh, you forgot to pay your traffic ticket. Okay, here, I'll take you at a default, make your fine, go to driving school. Like all that's pretty basic stuff. So I don't know if that's what he's doing. Maybe she supported him for that, but not currently. Now here, they say it is no secret that Mr. Roman's counsel, Ashley Merchant, the author of this filing, she worked tirelessly to defeat the incumbent judge against whom Wade ran. With only two candidates in the race, one of whom had been accused of serious judicial misconduct, Wade was definitely the most qualified of the candidates on the ballot. Okay, so great explanation from her. Okay, she turns around and says, the other judge was corrupt as can be, and he was the only other dude on the ballot, and I needed to get rid of that judge. This is a good lawyer, man. So, for example, Mr. Wade, apparently he was held in willful contempt. He failed to comply with a court order, right? He got held in contempt by his divorce court. And lawyers are not supposed to be held in contempt, okay? We are officers of the court. We have like a higher duty. So willful contempt for a lawyer, that's a big deal. I mean, he might have some bar problems, like state bar problems. If, I don't know what Georgia's bar looks like, but maybe. So here is what Ashley says. Mr. Roman requested copies of the invoices that are now attached to the state's response as Exhibit 3. On January 4th, the Open Records portal, Mr. Roman, in it, he made repeated requests to obtain them. But they said, sorry, we can't do it based on staffing levels and based on workloads. We can't give you the records you need. Now, the first time those invoices were ever made available was an exhibit in the state's response. So Fani turns around and attaches all these exhibits. She's like, here are all the records. I'm like, we never got them. Thank you for including them, though. So she says the state's response also blames Mr. Roman for not supplementing his motion once the divorce file was unsealed. But that's the whole point of an evidentiary hearing. That's why we're going to be here. And Mr. Roman intends to present the evidence at the hearing. Now, this is a criminal case. It's not a civil case. And it cannot be decided on ex parte, self-serving affidavits that might even be filled with lies. Some of the individuals who Mr. Roman has subpoenaed to testify, they have personal knowledge that Wade and Willis's personal relationship began before his appointment as a special prosecutor. So she gave her lover $1 million. In other words, they have knowledge that the assertion by Willis in the affidavit is false, okay? And man, they should have known this was coming. We've been saying this for weeks now. Ever since the original filing, I thought, we said it here, oh man, they have got the goods and they're just going to drip this out one day after another. And so Nathan and Fani, they really are painting themselves into a corner. Like, wow, not right. But this is the reason Mr. Roman is entitled to cross-examine these people, including Willis and Wade, on these material facts, going to the heart of the issue of whether they should be disqualified. In conclusion, for the foregoing reasons, Mr. Roman requests this court reject Fani's request to cancel the evidentiary hearing and leave it here so that we can all attend and enjoy and watch Nathan and Fani squirm theirself to bits up there in the Georgia witness box. Here is some more. Apparently, these are the emails that were sent back and forth, and these were relatively recent. And here is what you can see. Ashley Merchant. Oh yeah, she's doing the blow them up with emails thing, which is just a lot of fun. And she's pretty savage on this. She doesn't let up. Check this out. Okay, look at all these emails. This is how you drive someone totally bonkers. Starting back in September, I received a letter from Erica, says Ashley. Says, my request was submitted. At this point, it's been more than 3 days. I want to get the copies. How can I get them? 9/7/2023. Good afternoon. Following up again. It's been over 3 days. Don't have any documents. Since it's been over 3 days, we're hoping to get copies. Thank you. Let me know. That's at 3:56. They get a response at 4:40. Fulton County is working on your request. As soon as we have them, we'll notify you. Please allow a response to be given no later than next week. If anything changes, we'll notify you. Yeah, right. She waits next week. 9/11 response. Good morning. Please let me know if these requests will be ready by today. I requested them on Friday the 1st. Not been in compliance within 3 business days. It's now the 11th. I've not received them. Please let me know. See the attached contracts. Invoice will be released no later than Friday of this week. Now, I received the contracts. Thank you. But the contract for Nathan Wade references an original contract that is not included. May I have a copy of that contract, please? Weird. That one was left out. She says, see pages 5 to 7. She says, okay, thank you. But pages 5 to 7, okay, and a lot of other attorneys would like just give up at this point. Pages 5 to 7 are for the re-contract, and they state that on page 5. They reference the prior contract. I do not have the original contract. Please send that to me. Thank you. Thank you for sending those invoices. I got the invoices, but we still don't have the contract for Nathan Wade. That was the first contract. Please resend those. We also don't have these invoices. Please let us know. Thank you so much. She sends another email, 9/13, right? These are all like, back to back. Good afternoon, 9/14, just following up. We still have not received the original documents. We've also not received the invoices. Please let me know. I look forward to your response. Next day, good afternoon. Next day, good afternoon. I'm hopefully following up one more time. I have not received any bids or county approval. Please let me know if you have them. Additionally, not received this. Please let me know. Please log into the portal to see the attached documents. And that was on 1/29. Okay, 1/29, they finally get the documents. So this is the government dragging their feet. They don't want to give you the materials. Why not? Because they know it's not good. And they're scrambling together to get it all figured out. And here is the Vacation Express. Oh, it's great. So here, trip information. They went on a cruise. Oh, that's what this is. Nathan Wade, 2 passengers, the cruise authority. And it was $3,800 for the cruise. Here are the names, Nathan Wade right there, and Fani T. Willis. Oh man, too funny. So they fly into Aruba, from Miami to Aruba, and then Aruba back to Miami. And it's a cruise authority. So apparently it's oh, here it is. Oh, it's not a cruise. Maybe it is. I don't know. I'm not this fancy. I've never taken a cruise. I don't even know what I'm looking at. But here it says Hyatt Regency Aruba Resort and Casino. Oh, they did get the ocean view room. They did get it. Oh, I knew it. 3 nights accommodations for 2 adults occupying 1 room. Oh, Fani and Wade. They're getting their Aruba on. 1 king resort bed and an ocean view room with a European plan, whatever they're into. Whatever the European plan is that they're into. They check in on November 1st. They check out November 4th. It includes Aruba sale taxes, and it's a great deal. Wow. 1 king bedroom. They flew on American Airlines. Did they get first class? No, they didn't. They were back in the back of the bus. 32E, 32A. Where's A and E? Did they not sit together? Okay, on the way back they sat together. So 32E and F, but they had to get separate seats on the way over there, which I'm sure Nathan was actually happy about. He's like, oh gosh, find a little peace and quiet here. Just gonna read my book, be left alone. And I'll get there. And she's like, what do we want for lunch, honey? He's like, oh gosh. So anyways, so this is what the the trip looks like. And they're busted, man. It's all busted. And here's another one. More flights, hotels, clients of the Cruise Authority. They had a nice little stay over there. Isn't that something? On Fulton County taxpayer dollars. Wow. Well, I hope they had a very nice trip. Meanwhile, there's 19 co-defendants who are being prosecuted in order to fund this stuff. Here's the rest of it. Vacation Express. So, you know what I have to guess this is just the ex-wife, okay? She's just logging into their accounts and she's just like looking and printing the stuff off. Oh, it's just incredible. I mean, you can't even believe it. This is why, man, you know, prosecutors, they shouldn't indict each other. It's just a big problem for them. So anyways, this is just a ton of fun. And it sounds like Ashley Merchant and the defense, they've got the goods. They know they've got witnesses. They know they shared king bedrooms on, you know, in Aruba together. It's just incredible. But apparently, my friends, everybody else already knew about this, okay? This is not news to people in Georgia, right? Georgians already know that Fani and Wade have been indicting each other for apparently years now. It's not even that big of a deal. Here from MSNBC, this guy who used to be a Republican, for some reason they put him in charge of the RNC. Remember that? What a weird time that was. He is now on MSNBC, and he's talking with this dude who says, everybody already knew about this. Nothing even really to write home about. And here, let's refresh this one and see what this clip sounds like.
Asking right now for, as NBC News reports, Fani Willis, the DA who's been charged in the Georgia subpoena case, for documents. He wants her to come sit in front of his committee. She's responded, your request violates.
Okay, remember last week also, Jim Jordan sent her an official subpoena. And so he's talking about some of the prior responses with her.
Principle of separation of powers and federalism. How does this other narrative, this other piece aside on the relationship, she still has to deal with the reality of prosecuting this case and now I would say federal interference in that case with Jim Jordan?
Well, Jim Jordan, this is not new for him. He tried the same thing with Alvin Bragg, if you recall, and Alvin Bragg sent him a very tersely worded letter to let him know this is what you do and this is what I do. And I suspect that in many respects, that's the approach that Fani Willis is going to have, along with what she said about this as being a separation of powers issue. I think that the notion of tainting the jury pool is a valid one. I don't think that Fani Willis stepping away from this case eliminates that, because you're still talking about her office, you're still talking about her investigators, and you're still talking about her indictment. And so I think that she did the right thing by saying, look, this is what it is. She can't get in front of it because, what a lot of people may not realize is that in the streets of Fulton County, this was largely considered to be a public secret.
What?
In terms of this relationship, and that doesn't make it better or worse. What I'm saying is, I don't know that the impact on the jury will be as significant as people are thinking is going to be, because for the jury pool, it may not be that much of a surprise.
It's why, in Willis's response, she wrote, while the allegations raised in the various motions are salacious and they garnered the media attention they were designed, they don't provide the court with any basis upon which to order the relief they seek.
So I'm actually, like, if the judge doesn't dismiss the case and the judge doesn't disqualify all of Fulton County, I kind of want Fani to stick around. You know, I kind of want her to land here, because she is a big shiny object that is going to distract so much from any of the other allegations. And it's going to be like a lightning rod, right? She'll be symbolic of everything else that's happening in the Trump prosecutions. They're all as rigged. Not everybody was indicting their special counsel, but all of the prosecutors, all of these stories are concocted just like this one was. And they were just dumb enough to, you know, engage in this relationship, and it got exposed. Other prosecutors are not going to be as sloppy and as incompetent, but they are still as corrupt, in my opinion. All of these are created with one purpose in mind, which is to take out Trump, and they're executing the game plan. My friends, we're going to be here continuing to cover this. It's going to be a lot of fun. Roman's response is going to come out in full, probably before the evidentiary hearing happens. We're going to be here to cover the evidentiary hearing. I hope you join us as we do. The Fani Wade saga, the affair is just getting started, and it's going to have spillover into the entire RICO case, maybe resulting in a dismissal of that. So thank you for subscribing, wherever it is you're watching this. And thanks for checking out our new project, watcherlodge.com. We've got 3 events coming up in February, including a Building Your Own Survival Squad event, which we're going to be hosting a few days from now. All free. Come sign up. Catch us live, because the live replay was going to go away after 48 hours. So make sure you go to watcherlodge.com. Link is in the description, and we'll see you over there. We'll also see you right back here when we get into Wade and the Fani saga some more. See you back here on the next one. All right, my friends. That is it for us on the day. We had 2 good segments today. Fani gets called out. Apparently, they met at a municipal court conference, and they were enjoying the gaveling that was happening there with their robes, you know. Also, Jack Smith is raging at Donald Trump. Even Politico says it's kind of weird that he went on like a 20-page screed, kind of not even related to much, explaining himself. But we'll see what Judge Cannon does. And of course, they are officially at the freakout stage when it comes to the immunity decision not coming down. But we're waiting. Maybe that drops tomorrow or this week. But now, my friends, it is time to hear from you. And of course, today we are going over to watchingthewatchers.locals.com for our members only after party. We also do member streams in the morning. And so if you're looking to, you know, get a little bit more connection with our community, this is a great way to do it. We do streams in the morning, we do Saturday streams, and we do after parties. We're going to be going there in just a few short minutes, and we'll look forward to seeing you there. Now, some donos in the house. Thank you, my friends, for sending these in. It's a beautiful Monday. I appreciate your support here. We've got 1917 Beamer says, you know, I cared not about affairs. I want info on White House collusion, because didn't finish lead the prosecutor visit the White House. Yeah, so I agree. You know, like, again, the affair is just the crack of the facade, right? It just shows us that these are the type of people that we're working with who will do stuff and lie to us about it. And so the question is, how far do those lies go? How deep does this rabbit hole go? And that's really what we're interested in. Glocky says, Julie Kelly, shout out to Julie Kelly, Julie_Kelly2 on X, says, Julie Kelly just posted 4 minutes ago on X that during an interview, Harry Littman just admitted Fani Willis is getting help from outside lawyers to write her court briefs. Well, they're not doing a very good job. That last one was riddled with typos. It felt like an 8-year-old wrote that. Not good. Lucy Lou, what's up, Lucy? Is our newest supporter over on YouTube, YouTube Membos. Don't forget, you can grab the Telegram link, which is where we do our after parties. You can navigate over to the community tab section on the YouTube channel homepage. Scroll down, grab the Telegram link, and we'll see you there on the after party. We got Sandy says, here's another one from Julie Kelly. God, man, Julie, she's on it. Says, retweeted this, and it tickled my funny bone. Trump has psychologically enslaved the whack jobs to the point that she cannot make travel plans in advance because she knows they might have a chance to hold Trump in trial. Gotta love it. So, yeah, Chutkin said, I hope to not be in the country on August 5th. Says that if she is stateside, I'm in trial in another matter that is not yet returned to my calendar. Chutkin's comment is clear reference to the case, right? So there it is. I hope not to be in the country on August 5th, but if I am, it's because I'm in trial, which means the Trump trial might be going on August 5th. They're going to squeeze this thing in if they can. Thank you for that heads up on that from Sandy. This one from Glocky. Glocky is saying the CIA is going to cause a false flag and then blame it on Trump. Probably not a bad thought. Spud says Jack Smith, deranged thug and Star Trek cosplayer. I can see it. He kind of is like, what, a Vulcan maybe? Sandy says, planning for STHF, which is stuff hits the fan, is smart. Rob, have you noticed the attempt? Well, that's why we're doing it, Sandy. Thank you for that. It seems like an obvious thing to do, which is why we're planning on that. At watcherlodge.com, we're building our survival squad on Wednesday. Come join us. Rob, have you noticed the attempt of the left uniparty to recreate the 1968 DNC conventions? This summer could prove troubling. RFK projected to be a spoiler in Democrat elections. DNC holds a convention in Chicago. Racial violence and anti-war violence plague the convention. We have RFK Jr. a spoiler, pro-Hamas protests, attempts to inflame the race riots, and DNC holding a convention in Chicago again. Yeah, you're right about that. Like, there's a lot of similarities there, and that doesn't sound good, knowing where that goes. We got Captain says, hey, Captain, 13 months as a membo. A baker's dozen says, hot dogs like big buns, 24-hour rise time. Some dope. That's a good comment. Yeah, I mean, you don't want a big hot dog with a small bun, obviously, because then it doesn't fit. If you got a big bun, you want a big hot dog. You know what I'm saying? 24 hours in rise time, which is a lot. That's a lot of time. NY says, yes, Jack Smith, a good portion of the voting population, thinks that the Biden classified documents going into Senate Times were not investigated and his lawyers were allowed to cure. Meanwhile, the Biden administration was hell-bent on charging Trump. There is a low opinion of you. This is why the 60-page answer comes from your insecurity. Oh, okay. NY is ranting at Jack. I love it. Yeah, it was. It felt like a cope. It felt like, like I've written those letters, like at 10 a.m. at night, like, rah, rah, rah. And then you're like, I'm just going to wait until the morning to send this. And then you wake up in the morning and you don't send it. You're like, gosh, I'm glad I didn't send that. What a psycho, But Jack sent it. He sent it in. Quarter Native, what's up? Thank you for the heads up on this. I didn't know what it meant. White House Office of Records Management, the Worms. Isn't that a fun name? The Worms. NY says personal letters are exempt from Presidential Records Act. The law contemplates the president has a right to retain personal documents. All right. Yeah. Okay. You're right. That's right. And that's kind of where I was going with that. Like, it's the Clinton sock drawer case. Remember, he said, those are my personal documents. And they said, who am I going to litigate? Who am I to tell the president no? NARA did. NY says, the person who was acting archivist withdrew from Congress and Senate confirmation because she was a Democrat political hack and they knew she would affect the case against Trump. Wow. That's a good fact, NY. Yeah, I didn't know who that person was. And it was curious how they kept calling that person that by their title and not by the name, because the name would have stood out. Good to see you. Thanks for that, filling that one in. Uncle Ruckus is our newest supporter over on YouTube. Very nice to see you, Uncle Ruckus. If you want to join us on the members only after party, you can do that by grabbing the Telegram link in the community tab section down below. We got on the community tab section on YouTube. NY says the whole records problem was broadcast by Pelosi, who blasted that she didn't think Trump deserved a presidential library. That's the whole point for personal records, is to be held by a former president to establish a library. Jigam is here. Jigam, our meme smith extraordinaire, is reminding us, like Vienticus, to grab your bacon and hit that like button from Jigam. in the house. Thank you, Jigam. Our meme smith extraordinaire, and shout out to Vientikis. And don't forget to hit that like button like Vientikis is right now. NY says, how does Jack Smith suggest Walt Nada knew what was in the 64 boxes? What they charged him was for moving boxes? It makes no sense. Well, they say it was concealment because he was moving the boxes around, concealing the evidence. BH says, my wife has me move boxes from one room to another all the time. And probably back again, right? Back again and back again. But can we be indicted for it? Well, probably. I mean, are you going to vote for Trump? Well, you know how this country's going. Especially if your wife. If you're both voting for Trump, you guys are in big trouble, man. You better put those boxes back. B. Torn says, there is no crueler tyranny than that which is perpetuated under the shield of law and in the name of justice. Baron de Montesquieu. That's a good quote. Yeah, and I saw, I'm hearing a lot of this stuff now. It's like you have to vote against Trump or you're voting against America. You're voting against the Constitution. You're undermining the rule of law. In other words, like that's exactly what tyrants say. You have to do this or else. Same stuff we heard during COVID. Same stuff we hear ad nauseum. They're just using it now against Trump, and it's very transparent. We got B-Torn. Hey, Dolphin fan is the man. Bringing in new members. Thank you, Dolphin. Guess who's coming in? We got Derek Z, Jeffrey J, Pathfinder's coming in. Hey, Paul Me Knows in the house. Artsy Chick is also here, courtesy of Dolphin fan is the man. Bringing in 5 new members in the house. We got this one from Sandy. Says, listen to this loser emotionally manipulate the audience. Violent agreement. Add fuel to the fire. And this was another quote, it looks like. That was from Jen Psaki. That was another excerpt from, from these guys. Hey, that's also from Julie Kelly. Make sure you're following Julie Kelly too on X. Yeah, I think we got a clip from them. So thank you for that one. This old guy is in the house. What's up, this old guy? Says, who determined the boxes to be collected? Who determined the boxes to be collected? NARA? Who filtered the documents during the execution of the search warrant? NARA? Agents from the intelligence community? Smith actually seems to be making a pretty good argument for those agencies literally being a part of the investigation team. Yeah, I think you're right about that, this old guy. There was a whole, couple dozen pages of him explaining all the agencies that were involved. And then he says, but they're not a part of the team. Did you read your last 20 pages, my man? Fred says, what's up, Fred Pedamonte and his rascally dog, Johnny. What's up, Fred? Says, how was Jack Smith allowed to use a DC grand jury for indictment of crimes in Florida? Worms is right. It's killing J.S. Cannons on this case. So Judge Cannon, yeah, we're going to see how she rules. She is not a Judge Chutkan, and she has already held Jack Smith to account on other issues that they're very unhappy about. But you're right. She's also asked them about that. Why are you using foreign grand juries to bring charges in my jurisdiction? Todd says, I have some laser engraved gifts for you. What's your address? Well, that's really sweet, Todd. Thanks for doing that. So if you go to robertgovea.com and you scroll all the way down, you'll see my mailing address down there. It is a 522 North Central Ave, 1802, Phoenix, Arizona, 85001, if I remember that right. But it is on robertgovea.com if you just want to copy and paste. And thanks for even thinking about us. Laser engraved gifts. Sounds interesting. Sounds fun. What's up, Todd? Thank you, Todd. Thanks for being a membo and for sending me cool stuff. What's up? CA Smirk says, voters deserve to know about that Biden laptop, OMFG. Yeah, but the same FBI was censoring Americans to prevent us from knowing anything about that. And they were colluding with the social media companies to do it as well. We got CF Rob over on Rumble says, okay, if they left out the word deny in the conclusion, then they didn't say the court should deny. That's right. If they left out the word deny, what else did they leave out? It's true. I think the whole motion should just be rejected. You want us to what? Well, your conclusion didn't properly say what you wanted us to do, so therefore your paper goes right into the shredder. Thanks. I agree. NY says, Trump isn't charged with insurrection, but details, Neil. Well, he is in Neil's mind. Okay, they wake up every day living in an insurrection. Hey, Super Buff is here on Rumble. What's up? says, hey, Robert, my favorite history channel on YouTube dropped a very detailed 2020 election rundown. Bomb. All should see and share. And so let's plug this real quickly. Let's see. Election Fraud History Part 1. And this looks like, oh, it's already got the tag. Oh, it's already, so you know it's going to be good. 2020 election history. This is by a channel called Forgotten History. Looks awesome. And it says here, elections and other political processes are pivotal to this. Elections can either advance or set back a country. It looks good. 30 minutes. Bunch of sources in here. Looks great. Cool. So I'll check this out. And here, my friends, if you want to check it out, this is what it looks like. 10th Legion pictures.
Elections and other political processes are pivotal to the quality of a country's government.
Ooh, looks good. Sounds good. Nice little music there. Okay, so Forgotten History is the channel. Go check it out, my friends. Learn more about our rigged election. And thank you, Super Buff, for the heads up on that. Looks like a good one. We got to stay educated and apprised of what's happening. Thanks for the heads up. John is here clipping for us. We got CA Smirk says, the Georgia litmus test. If this were a Republican doing all of the things Big Fani has done, would it fly? Oh my gosh, no way. Probably would have been indicted for another conspiracy or something. Misappropriation of funds, demands to resign. And even if a Republican was prosecuting a Democrat, right, they flip out about that. So it's true. Sandy says, I am most interested in the GAR in the RICO case, Georgia RICO case, and watching it implode. The federal RICO is bad enough as far as violating a person's constitutional rights, but this Georgia version is just off the charts. From Sandy over on the locals. Thank you, Sandy. Good to see you. Knox is here, criminal defense attorney in Texas, says, happy Monday, all. Says, Counselor Merchant is deliciously cutting. And didn't Fani state that she knew Wade from law school? Yeah, I don't know. Story keeps changing. Yeah, Merchant is fun. It's a lot of fun. I wonder if I asked Nathan about his cruise. Nathan, would that be a question that you'd have a difficult time answering? I love it. Aaron, what's up? Aaron is our newest shout out supporter over on the YouTubes. Welcome aboard, Aaron, and thank you for joining us on the YouTubes. GBA is over on Rumble, says, keep up the great work, Robert. Well, thank you, GBA Coins. We certainly will. Thanks for being a membo. Thanks for supporting us on Rumble. We love having you. We got D McGrorty. D McG says, Rob, the code to join locals is not working. Thank you. I'm so much grateful for the scholarship. I'm very grateful for it. So it's working for everybody else. So I think everybody else has gotten it working. So I'm not sure what's happening on your end, but I'll certainly be happy to talk to you after the show and we can dissect that. But I'm glad that you're trying to join, and we're looking forward to see you inside at watcherlodge.com. Knox says, so now Wade has committed falsification of a legal document, which would be a Class B misdemeanor down here. Yeah, we'll see. We'll see what happens to him. I mean, if I were a judge and he lied to me in an affidavit, I would be furious. So maybe the judge will make a referral back over to Fani. Here, Red One says Fani's cheeks are about to get blasted off in court. It's going to be a rough hearing for them, I think. It's going to be a rough one. Sandy says, interesting words of safe house paid by the taxpayers. Seems specific to me. Plain fare was indirectly taxpayer funded, but cannot be put in a legal filing as taxpayer funded. What the heck is this safe house taxpayer funded? A merchant must have evidence of Fani authorizing state funds to pay for that. From Sandy. Good to see you, Sandy. We also got Crash says, recusal is no longer an option. They are in the soup. Only hope for Fani is for Nathan to fall on his hot dog, write a book, and go away. We got Fred is here. What's up, Fred? Says, interview with Jay Wade, the Scorpion Queen, the lawyer, is on YouTube, and I'm sure that was a lot of fun. And Sandy says, I personally am looking at this judge's behavior as hope or no hope left in our entire judicial system. So far, this is not looking good for our system. We have the very best system in the history of the world, but it appears a few corrupt humans in this day and time might be enough to destroy it. I pray we have something left as a framework to rebuild. Good to see you, Sandy. This one from Cowboy Rob says, How is Jim Jordan out of line, as she would say, in respect to separation of powers when she did the same thing, going and speaking to the White House? Yeah. Well, I think she just says, you're Congress, I'm a state, you've got no authority here. His response is like, well, did you take our federal government money? Yes or no? Then there's not that much separation there. Thanks for playing. Felix says, Fani loves that gavel and that Nathan hot dog. He loves to use it to gavel Fani's Fani. Ugh, bad visuals. Hey, Richard says, hey, Rob, how's it hanging? Well, I'm seated right now, but I'm having a great show. We got Cowboy says, who determines which agents have clearance enough to touch any of those classified document boxes? That's a good question, right? And it's apparently why they use that taint team, that preliminary team, to go in and to vet it and then pass it off and then, dispose of it, distribute it. But the point I think Trump's team is making is that everybody who is in that chain is part of the part of that prosecutorial team. We got what's up from Cowboy Rob. Contra is here. What's up, Contra? Thank you for the nice dono. I appreciate that, Contra. We had this one from Sandy. Says, Rob, I don't know what the lodge is. I'm new to this locals community. Can you guide me where to find it? I like old school survival info, and I believe we're going to face troubling times. Yeah, Sandy. So it's very easy. It's at watcherlodge.com. Watcherlodge.com. I totally agree with you, by the way. I think that times are going to get a little bit messy out there. And so if you go to watcherlodge.com, link is down in the description below. This is what it looks like. We've got a growing community over here. We've got our fitness challenge that we just wrapped up. So we did 31 days of our fitness challenge. We gave away some scholarships. We gave away some fun stuff as part of our fitness challenge. But now this has been retired. We're done here. And so now we're going into a bunch of other activities. So on Wednesday, we're talking about building your survival squad. So you can come here and register for this, add it to your calendar. It's free. It's going to be up for free here for 48 hours, and then it's going to go back behind the paywall into the Lodge archive. So you don't need to pay for anything to sign up for it, but come and join us. Then on Saturday, we're unboxing an SDS 200 scanner. Okay, this is something that I have sitting in a nice box over here. It is a very broad range scanner, so you can listen to all the emergency protocols and things like that. That's Saturday, 10 a.m. We're going to unbox that, talk about that. And then on Friday, February 16th, we're going to have my good friend, Jason Campbell, who is a Zen wellness master, and he does breathing. He knows ancient knowledge. He's going to help us talk about mental turbidity and clearing out the mind and overcoming political stressors and a lot of good stuff. He's really great to listen to. But all this is taking place at the Lodge, only on the Lodge. It's not on YouTube. It's not anywhere else. It's free to come join all these things, and we're going to be filling up the event calendar with a bunch of other stuff. And it's going to be a very fun year building the Lodge. So come and join us and check that out. Watcherlodge.com. Links are down in the description below. And so, Sandy, thank you for asking about it. And thanks for checking it out, my friends. We're looking forward to seeing you over there. Let's also check out X. Who is joining us on X? Before we wrap it up and go over to watchingthewatchers.locals.com for our members only after party. YouTube friends, we'll see you on Telegram if you care to join. Who is watching us today? We got 30 viewers on X. Oh my goodness. Wow. Okay, so check this one out. So Paul Minot's joining us. Says, the Watcher Lodge is awesome, Rob. You're doing good things. This is from Paul Minot, our friend. He says, your links to Ken Wells through Genius Network, woo, helped me get through a tough period, as did being a Watching the Watchers member. Thank you, my friend. That's awesome. Okay, so shout out to Ken Wells. I mean, gosh, Ken Wells is like an awesome dude. Okay, Ken, love you out there. He's a great dude. And yes, through Genius Network, I'm very glad, Paul, you're doing well. We're glad to see you back in the forum, my friend. Very good to see you. And let's see, we got this one from Paul. He says, you made me think of Fani's taint. Thanks a lot, buddy. That's the old vomit face. Barbs is here. Says, my, what do we have here? Oh, yes, that's what we read through here. Courtesy of Technofog. And Barbs loves Alaska. Very good to see you both. We got, what's up, Goofy for Jesus says, great work. George is in the house. Forgot my name says, great show. L says, you're a great storyteller. I've been laughing for 10 minutes. Well, look, I didn't need to tell the story. there's not much I could add to this conversation. Okay, the story tells itself. And here, Elle's a lawyer here too, so appreciation factor is up. I've been laughing for 10 minutes. I can't take credit for this one. I mean, they're the ones who are going on cruises to Aruba. Laura says, dismiss all the bogus witch hunts and the election interference. B. Torn says, prosecute tyrannical. That's a fun one. And Jack's clapback is well-documented history. B. Torn's in the house. That guy. What's up? Base Kafefi says good. Richard Vickers is over there saying Biden, this wasn't showing up, says Biden weaponized NARA. Since under the PRA, the president can declassify documents at will, there is not a specific time period to send the documents to NARA. This isn't even a criminal statute. It's always been handled bureaucratically. Amazing. Good to see you, Taco Bill's over there, and James is over there. My friends, that's what it looks like on X. And if you want to join us, come and join us at Rob Govea ESQ as well. Another place to follow us on X. And when you're out there on X, be sure to like each other, follow other watchers, like their stuff, retweet their stuff. Our community will be stronger together if we all engage out there in the wilderness, in the wild, on X and elsewhere. But my friends, that is it for us on the day. We are going over to watchingthewatchers.locals.com for our members only after party. And so we would love to see you there. We're going to debrief, and we also have our members only streams in the morning, watchingthewatchers.locals.com. Come check us out. PDFs, newsletter, shop available, robertgovea.com. And Watch Your Lodge, go there, register for building your survival squad. We're going to talk about the 5 roles that you need for your survival squad in the event of a chemical problem like in East Palestine. If we have a foreign invasion or a foreign attack, if we have a situation where a wildfire pops up and our government can't figure it out, we need a survival squad. And so we're going to get prepared. Hopefully you come join us. Sovereignty and self-development, watchyourlodge.com. We'll see you over there. Before we go over to watchingthewatchers.locals.com, big thank yous to our meme smiths and our mods. We got Vianticus Prime in the house. K-Bean. We got Just Cause, Playing Hooky, our friend Ronnie Cole, Zulu's here. We got Beyond Geo, Zach Nichols, our friend John Allen, Janek, Dog Digger, Donut Mind Me, and others modding down the fort for us, along with our meme smiths, Geegum Geegum, Nathan NA10, and our friend Sleepy Dogly over on the X. My friends, that is it for us on the day. We're going to see you over at watchingthewatchers.locals.com for our members only after party. But if we don't see you there, well, we're going to be back here tomorrow to get into it all again. It's going to be a busy one, and we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends, and a beautiful week. We'll see you right back here tomorrow. Bye-bye.